eyes. The President, please be seated. The President, the court is now in session. We will now give the floor to the Civil Parties Council Group 3 to make their response.
Thank
you, Mr. President. I'm representing Civil Party Group 3. Together with Ms. Martin Jacquin, my colleague, we would like to make our response to the statement by the defense on the issue of personal jurisdiction over the accused Kang Kiet alias Dutch. After having heard the statements and the response by the co-prosecutors, we are of the view that the defense submission is not based on any legal ground. The victims who are here are not to seek any revenge. Their only wish is to have justice and forms of reparations. One of the observations that we make is that repeatedly the defense team raised the issue of the role and responsibility of the accused in comparison to other prison chiefs, totaling 195 prisons. He is just one of those 190-something prison chiefs. And on the point of law in identifying the suspects who are the most responsible, they raise certain legal grounds, and we are of the view that those certain legal grounds are inappropriate. For instance, the law on the Paris Peace Accord, the law on outlawing the Khmer Rouge, they did not provide any identification of the people within the category of the most responsible persons. Only the ECCC law shall be raised in conjunction with other relevant international jurisprudence. The second point is that the defense team raised the issue of the fact that their client is just one of the many prison chiefs. It is groundless to raise such a matter before this chamber. The assertion that Dutch within the party rank is equivalent to a commander of a regime, and that there is no law during the Khmer Rouge regime. If we consider these arguments, if there is no law during the regime, what did they rely on? Of course, they used the law of the wild. It means whoever senior will defeat the lower ranked one or the weak one. So the strong ones always beat the weak one. That is the argument raised by the defense team. And another point that the defense raised is that the co-prosecutors only charged one of the many prison chiefs, and the rest of the prison chiefs were not charged. I think that is inappropriate. The charges against this person is the most appropriate. Because if we practice the law of the world, it means the cows would always, the tigers would always eat the cows and not the cows into the tigers. And that is clearly stated through his role and responsibility as chief of S21 that he arrested many other senior cadres of the Khmerus. Regarding the details of the legal grounds of our response, I would like to give the floor to my colleague, Ms. Jatin Makang.
Monsieur le Président,
Mr. President, Your Honors, Mr. and Madam Co-Prosecutors, Counsel for the Defense, Counsel for the Civil Parties, my fellow colleagues, on behalf of the interest of Civil Party Group 3, it is my honor to answer the Chamber's question asking for all supplementary explanation on the following. Is the language senior leaders of democratic Cambodia and those who are most responsible, as indicated in the ECCC agreement and the ECCC law, a jurisdictional requirement that is subject to judicial review? Or is this language a guide to the discretion of the co-prosecutors and co-investigating judges that is not subject to judicial review? Allow me to raise some legal points that have already been raised by other parties, but I hope that we will be able to bring forth new elements and analysis which will allow you for greater contemplation. We wish to recall some of the arguments raised by Duke in his appeal brief with respect to the trial chamber's personal jurisdiction. Indeed, personal jurisdiction is restricted to senior leaders of democratic Cambodia and to those most responsible for the crimes and grave breaches of national and international law. Neither the agreement nor the ECCC law expressly defines senior leaders of democratic Cambodia or those most responsible for the crimes. It cannot be inferred from neither the agreement nor the ECCC law that Gang Gekyu, alias Duke, is one of those most responsible for the crimes committed. Indeed, the defense claims that the trial chamber considered Duke as forming part of those most responsible for the crimes in order to try him at any cost. The reason why the trial chamber refused to consider Rule 87, as requested by the lawyers for the defense, was because the judges knew fully well that in reality, no elements allowed them to apply Article 1 of the agreement and Articles 1 and 2 new of the ECCC law to Gang Gekyu alias Duke. Accordingly, in the introduction of its judgment, the trial chamber demolished the agreement between the United Nations and the royal government of Cambodia. Indeed, it claims that it violated the fundamental principle enshrined in the common law, principle of legality, by relying on common law authorities for its interpretation of this principle in such a way as to call into question Article 1 of the agreements and Articles 1 and 2 new of the ECCC law, which restrict the personal jurisdiction of the Extraordinary Chamber to senior leaders and those most responsible for the crimes. Had the trial chamber considered the evidence submitted by the defense in their final submission, it would have recognized that it did not have jurisdiction over Gang Gekyu, alias Duke. This is indeed why the trial chamber evaded the issue, claiming that the defense preliminary objection was belated. The defense claims that there is a large body of exculpatory evidence adduced by Duke himself. The evidence regards his role and real functions. There was evidence adduced by the prosecution that reveals that the accused is not within the purview of Article 1 of the agreement nor of Articles 1 and 2 of the ECCC law. And unfortunately, the trial chamber omitted to consider that evidence, which amounts to a grave error. This situation arose because in their preliminary investigation, the co-prosecutors did not focus their investigation on the senior leaders who were most responsible for crimes at the S21 Center, but only for the role and functions of Ganggek Duk during the period from 17 April 1975 to 6 January 1979. It was precisely this error which led to their mistaken belief that he was among those who were most responsible for the crimes committed at S21, without he or his lawyers being afforded the opportunity to adduce evidence to the contrary. Hence, the co-prosecutors were misled into thinking that the ECCC had jurisdiction to prosecute and try Ganggek, since he was to answer for his acts as one of those most responsible for the crimes committed during the DK regime. The co-prosecutors even held the view that he comes under the category of senior leaders of democratic Cambodia. For their part, the co-investigating judges revisited this conclusion, indicating in their closing order that Ganggek could be considered in the category of most responsible for crimes. All of the foregoing elements show irrefutable proof presented by the co-prosecutors and the co-investigating judges by means of precise legal arguments or sufficient evidence that Ganggek is within the jurisdiction of the ECCC. Influenced by all of these elements, the trial chamber therefore tried Ganggek on the incorrect premise that he came under its jurisdiction. Moreover, it dismissed the defense objections simply on the grounds that they were belated. Defense counsel were apparently not afforded the opportunity from the outset to respond to the co-prosecutors' charges, and the co-prosecutors maintained those charges when they forwarded the case containing the charges against Ganggek. They claim that the chamber failed to fulfill the obligation of verifying before accepting to be seized of the case file 001 and whether it had requisite jurisdictional requirements to enable it to exercise personal jurisdiction over Ganggek in accordance with the provisions of Article 1 of the agreement, Articles 1 and 2 new of the ECCC law. Moreover, the dissenting opinion of the international judge reflecting his belief that the trial chamber did not have jurisdiction to try Ganggek amounts to proof that all the trial judges, both national and international, knew and recognized that the ECCC lacked the personal jurisdiction to be seized of case 001. In conclusion, the trial chamber did not have jurisdiction over Ganggek. He held a junior and not senior position, both within the ranks of the government of Democratic Kampuchea and within the Communist Party of Kampuchea. The proceedings in Case File 1 conducted before the trial chamber from 30 March 2009 to 27 November 2009 must be considered as the result of an error by the chamber in the exercise of its personal jurisdiction. I believe that I have summarized the position that has been put forward by the defense with respect to the erroneous characterization. I shall take the care to recall the bench a few provisions as set out in the resolution of the UN General Assembly. I also want to cite verbatim the first article, whose French version leaves absolutely no ambiguity with respect to the definition of senior leaders and most responsible for those crimes. Indeed, Article 1 reads as follows, and I quote, "The purpose of the present agreement is to regulate the cooperation between the United Nations and the Royal Government of Cambodia in bringing to trial senior leaders of Democratic Cambodia and those who were most responsible for the crimes and serious violations of Cambodian penal law and international humanitarian law and custom and international conventions recognized by Cambodia that were committed during the period from April 17, 1975 to January 6, 1979, full stop." This allows the court to try either senior leaders in a conjunctive manner. The French version of this text does not allow for any doubt to hover. In fact, I regret that my learned colleague from the defense has interpreted the text in his way and has neglected the interpretation of the French text. And I would ask that he revisit his observations made before the bench and refer to the French version of this article. The second article of the agreement refers to the jurisdiction of the ECCC, as it clearly specifies that the extraordinary chambers have personal jurisdiction over senior leaders of Democratic Cambodia and those who were most responsible for the crimes referred to in Article 1 of the agreement. That very specific article cannot be read differently. It is precisely in this context that the law of 27th November 2004, the law on the establishment of the extraordinary chambers of the courts of Cambodia, duplicates this text. It reads that senior leaders and those most responsible for the crimes committed in Democratic Cambodia, hereinafter designated as suspects. Once again, in the French version of this agreement, there is no other interpretation that is possible given its wording. The two subjects, the two categories of those who may be tried are those over whom the court has jurisdiction. Very quickly, Article 3 refers to the 1956 Cambodian Criminal Code, Article 4 to the Genocide Convention, Article 5 to the Crimes Against Humanity, Article 6 to grave breaches, Article 7 to the Hague Convention for the Protection of Cultural Property, and I would also call to your attention Article 29, that Defense Counsel was completely silent on. And yet Article 29 is absolutely primordial and would convince anyone that Duke fits into the category of most responsible. It reads as follows, Article 29, any suspect who planned, instigated, ordered, aided, or abetted, or committed the crimes referred to in Article 3, new 4, 5, 6, 7, and 8 of this law shall be individually responsible for the crime. The position or rank of any suspect shall not relieve such person of criminal responsibility or mitigate punishment. The fact that any of the acts referred to in Articles 3, new 4, 5, 6, 7, and 8 of this law were committed by subordinate does not relieve the superior of personal criminal responsibility if the superior had effective command and control or authority and control over the subordinate, and the superior knew or had reason to know that the subordinate was about to commit such acts or had done so, and the superior failed to take the necessary and reasonable measures to prevent such acts or to punish the perpetrators. The fact that a suspect acted pursuant to an order of the government of Democratic Cambodia or of a superior shall not relieve the suspect of individual criminal responsibility. It is within this very specific legal context that the co-prosecutors were compelled to research and identify those who fall within the personal jurisdiction of the ECCC. Review of the facts and evidence collected led the co-prosecutors to retain the basis of the charges in accordance with the aforementioned text against Gengekyu alias Duk for his role and functions as chairman of the S21 prison center. It emerged from all of the elements brought together that the accused, contrary to his allegations, was not merely an executor without or bereft of the possibility to express his opinion. Duke was deputy chairman and then chairman of S21. He was appointed by one of the members of the Standing Central Committee during the period in question on account of his experience in managing the detention center M13, where he confirmed his faith in the regime and confirmed his status and qualifications as the best interrogator. His appointment as chairman of S21 cannot relieve him from individual criminal liability for the crimes committed at S21. The accused was actively involved in directing S21. He was a supervisor, he participated in interrogations, he made annotations on confessions by which he gave the party leads and clues on new and potential traitors to search for. He managed the staff members who were entirely under his orders, and he taught them interrogation and torture techniques. Gengekyu had full control over the actions of his subordinates and over everything that happened at S21. He knowingly orchestrated and participated, directly or indirectly, to the elimination of 12,273 people. He supported that policy and the terror methods used. The acts of extreme gravity perpetrated at S21 under his orders constitute crimes against humanity and grave breaches of the Geneva Conventions. The co-investigating judges confirmed this characterization upon conclusion of the investigation of the case. The accused and his counsel are therefore wrong to argue that the chamber erred by finding that he was one of the principal perpetrators of the serious crimes committed at S21 from 17th April 1975 to January 6, 1979. It cannot be inferred that this characterization is not firmly grounded in law for the reason that the co-prosecutor's introductory submission characterizes Gengekyu as one of the senior leaders of the government of Democratic Cambodia. The co-investigating judges were bound by the facts and crimes set out in the introductory submission, but they had the discretion to characterize those differently. The argument, therefore, made by the accused does not stand. The assessment of the characterization of the suspect, that is to say, over whom the chamber may exercise personal jurisdiction as defined in the founding legal text of the ECCC, must be subject to a review by the co-prosecutors and an additional review by the co-investigating judges at the end of their investigative action. It is in this context that the trial chamber was seized of the crimes alleged during the period of 17 April 1975 to 6 January 1979 by a person who specifically falls under the personal jurisdiction of the chamber as provided for in the founding text of the ECCC, and that person is Duke. However, the chamber, seized of the charges made against a suspect, such as Duke, cannot content itself solely on the terms of its seizing. It is within its jurisdiction to consider the facts and evidence that are brought before it and verify if, effectively, it may exercise its jurisdiction based on the same facts and its jurisdiction over the suspect, in this case, Duke. Effectively, the answer that we submit to the question you put before us is as follows. Indeed, the definition of the term senior leaders of Democratic Cambodia and those most responsible for the crimes mentioned in the law on the ECCC constitutes a jurisdictional requirement that is subject to prior judicial review by the co-prosecutors and the co-investigating judges. But yes, the chamber does hold the discretion to proceed with recharacterization. In fact, the chamber was entirely aware of this imperative and proceeded with a minute and detailed examination of the facts, charges, and evidence regarding the accused for the purpose of delineating the contours of its personal jurisdiction. The chamber has, moreover, addressed this observation. Indeed, The Chamber examined each of the crimes that the accused is charged with and explicitly recalled under Section 2.5.2.5 that the evidence satisfies the Chamber that S21 was an integral part of the CPK political and military structure and was considered vital to achieving the party's political objectives. It implemented CPK policies such as the smashing of CPK enemies. The accused's role as chairman of S21, reporting directly to members of the Standing Committee, gave him a unique vantage point from which to implement this policy. The Chamber infers that he was aware of the points from which to implement this policy, and that S21 was an important component in implementing it. The Chamber recalled that the co-investigating judges did not allege that the accused was a senior leader of Democratic Cambodia, but instead charged him as being one of those most responsible for offenses committed during the temporal jurisdiction of the extraordinary chambers. The Chamber recalled the dispositions of the closing order, according to which it was said Duke was not a senior leader of Democratic Cambodia. He may be considered in the category of most responsible for crimes considered during the period in question, due both to his formal and effective hierarchical authority and his personal participation as Deputy Secretary, then Secretary of S21, a security center which was directly controlled by the Central Committee. Neither the agreement concerning the ECCC nor the law on the establishment of the ECCC expressly defines quote-unquote senior leaders of Democratic Cambodia or those who are most responsible for the crimes committed. However, the group of experts on Cambodia, struck in 1998 by way of a UN General Assembly resolution, accordingly recommended that any tribunal focus upon those persons most responsible for the most serious violations of human rights during the reign of Democratic Cambodia. This would include senior leaders with responsibility over these abuses as well as those at lower levels who were directly implicated in the most serious atrocities. The jurisprudence of other international tribunals, which have also examined the notion of most senior leaders suspected of being most responsible, have considered both the gravity of the crimes charged and the level of responsibility of the accused. It was drawn throughout the hearing that the accused had participated in the training of the interrogation methods as well as took part in the planning of the center's activities. As chairman of S21, he supervised the overall functioning of the center by specifically making annotations on the confessions of the detainees and ordered execution. S21 was an important security center in Democratic Cambodia. It was considered the organ of the Communist Party of Cambodia. Its leadership reported to the highest echelons of the party. It conducted activities on a countrywide scale, and high-ranking officials and notable prisoners were incarcerated there. More than 12,000 people were detained at S21, a figure or toll that remains incomplete because the practice at the prison was not to register all prisoners. Victims from all over Cambodia were sent to S21. This is what enabled the prison to spread its scope of activity throughout the entire country. S21 operated from October 1975 to the start of 1979. Throughout the entire time, DK existed. As such, the Chamber agreed with the conclusions drawn by the co-investigating judges and believes that in his capacity as one of the senior leaders of crimes and serious violations of Cambodian and international law committed during the period from 17 April 1975 to 6 January 1979, the accused is within the personal jurisdiction of the ECCC. It is therefore necessary for the Chamber to determine if the accused was one of the senior leaders. As such, upon review of the aforementioned documents, it may be concluded that the co-prosecutors, during the initial stages of the proceedings, had focused on the issue as to whether Genghikyu could be defined as one of the senior leaders or most responsible. Secondly, that the co-investigating judges had asked themselves the same questions and partially amended the preliminary conclusions of the co-prosecutors. And thirdly, that the trial chamber had also specifically asked the same question and answered in the affirmative. I now wish to make a few remarks with respect to procedure.
We wish to remind that pursuant to the agreement, the extraordinary chambers exercised and once created, the ECCC issued their internal rules. The internal rules has the object of consolidating applicable Cambodian procedure that is applicable before this court. The agreement provides, as well as the law on ECCC provides, that reference may be made to extra rules when the rules in effect do not deal with a specific question, or in case of uncertainty regarding their interpretation, or if the question is raised regarding their compatibility with international standards. But the internal rules is very clear on this point. Cambodian law before the trial chamber and international rules of procedure may also be used as a reference in case of need. In the context of the difficulty presented by the issue, the preliminary objection raised by the accused, there is nothing to challenge because Rule 89 is perfectly clear. All questions